The bailiff took her by the arm, not roughly, but firmly enough that everyone in the courtroom saw it. A black woman in a torn jacket, unwashed jeans, and sneakers with the soles separating at the toe was being guided toward the courtroom door. She had been sitting in the back row of the gallery. She hadn't spoken. She hadn't disrupted. She had been listening to the trespassing case being argued against her, the one where she wasn't allowed to speak because she didn't have an attorney. Judge Finn Sloan had looked at her once, early in the proceedings, the way people look at something that isn't supposed to be in the room. "Ma'am, this is a court of law. If you do not have representation, you'll need to leave and return with counsel." The woman stood. She didn't argue. She reached into a torn plastic bag, the kind you get from a bodega, and pulled out a single piece of paper. Yellowed, folded 3 times, cracked at the edges. "Your Honor, I don't need an attorney. I need you to look at this." The judge sighed. "Ma'am, this is a property deed, recorded with the Fulton County Clerk's Office in 1962. It covers this block, all of it, including the building this courtroom is sitting in." The courtroom went still. The woman's name was Siya Kennison. She was 31 years old. She was homeless. She had been sleeping on a vacant lot on Edgewood Avenue in downtown Atlanta for 4 months, the same lot where she was arrested for trespassing. The same lot that a billionaire developer named Curtis Prescott had purchased 6 months ago as part of a $400 million redevelopment project. The lot belonged to Siya's family. The deed proved it. And the man who filed the trespassing charge was sitting in the courtroom gallery, watching a homeless woman in torn sneakers hold the one piece of paper that could stop his entire project. What happened next didn't just destroy a real estate deal. It opened a fraud investigation that reached back 60 years. And it started with a deed that had been hidden inside a Bible on a shelf in a shelter for women. Pause for 2 seconds and help me do something fun. Comment your city and country. I want to see how global this community really is, and I am looking for the 2 viewers watching the farthest apart today, so I can pin the winner. Now back to the story, because things are about to get very interesting. Siya Kennison hadn't always been homeless. 3 years ago, she was a line cook at a restaurant in Midtown Atlanta. She had a studio apartment. She had a daughter, May, age 5 at the time. She had a life that was hard but stable. The kind of stable where you pay rent on the 3rd instead of the 1st, but you still pay it. Then the restaurant closed. Then Siya got sick, a kidney infection that put her in the hospital for 11 days. No insurance. No savings left after the medical bills. The landlord wouldn't wait. Siya and May moved in with a friend. The friend's lease didn't allow additional occupants. They were asked to leave after 6 weeks. Siya applied for housing assistance. Waitlist, 14 months. She applied for shelter placement. The family shelters in Atlanta were full. She and May were placed in a women's shelter on Boulevard, a clean, safe building, but temporary. 90-day maximum stay. After 90 days, Siya was on the street. May was placed with Siya's cousin in Decatur. Siya visited 3 times a week. She walked 4 miles each way because the bus cost $2.50 and she needed the money for food. The vacant lot on Edgewood Avenue became her place. Not a home, a place. A patch of dirt behind a chain-link fence where nobody bothered her. She slept against the brick wall of an abandoned laundromat with a sleeping bag and a backpack that held everything she owned. Clothes, a phone with a cracked screen, a Ziploc bag of documents, and a Bible. The Bible had belonged to her grandmother, Pam Kennison. Pam had raised Siya after Siya's mother left when she was 4. Pam had worked as a seamstress in a garment factory on Auburn Avenue for 31 years. She lived in a shotgun house on Edgewood Avenue, 1 block from the lot where Siya now slept. Pam died when Siya was 19. After Pam died, the house was condemned by the city. Siya was too young and too broke to fight it. The house was demolished. The lot sat empty for 12 years. What Siya didn't know, what nobody had ever told her, was that Pam Kennison's property was not just the house. The deed that Pam's father had recorded in 1962 covered the entire block. Not 1 lot, not 1 parcel. The full block, 2.4 acres of Edgewood Avenue, including the vacant lot,
the abandoned laundromat, the corner where the bus stop sat, and the property where the Fulton County Annex Courthouse had been built in 1987. The deed had never been transferred. It had never been sold. It had never been challenged. It had been sitting inside a Bible, slipped between the pages of Psalms, for over 30 years. Siya found it 3 weeks before her arrest. She was turning the pages of Pam's Bible at the shelter, the way she did every night before sleeping, not for the scripture, but for the feeling of her grandmother's hands on the same pages. A folded piece of paper fell out. She opened it. She read it. She didn't understand all the language, but she understood 2 things. It was a deed, and it had her grandmother's family name on it. She put it in the Ziploc bag with her other documents. She carried it everywhere. Subscribe now and stay to the end, because I am going to show you one title search that Curtis Prescott's legal team conducted before buying this block. And when I reveal what they found, and what they chose to ignore, you will understand why this billionaire's entire $400 million project was built on a lie. This is not drama. This is property law. And we are about to break down exactly how they buried it.
Curtis Prescott was 57 years old. He ran Prescott Development Group, a $2.8 billion real estate firm that specialized in urban redevelopment, converting industrial corridors and blighted neighborhoods into luxury mixed-use projects. His portfolio included 12 major developments across Georgia, the Carolinas, and Florida. His Edgewood Avenue project, called the Edison, was his largest. 4 city blocks, $400 million in projected development, luxury apartments, retail space, a boutique hotel, and a community plaza that would replace the vacant lots and abandoned buildings that had sat empty for years. The city had approved the project with fast-tracked permits. The mayor's office had issued a press release calling it the most significant investment in Atlanta's East Side in a generation. To assemble the 4 blocks, Prescott's team had purchased 23 parcels over 18 months. Most were bought from the city's surplus land program, properties that had been foreclosed, condemned, or abandoned and were being sold at auction. A few were purchased from private owners. All title searches were conducted by Prescott's in-house legal team. Siya's block, Block 3, was purchased from the city for $1.2 million. The city's surplus listing described it as unencumbered municipal property, clear title. But the title was not clear. When Prescott's legal team conducted the title search, they found the 1962 deed. It was filed in the Fulton County Clerk's Office, Book 4417, page 312. It recorded the transfer of 2.4 acres on Edgewood Avenue to James Kennison, Siya's great-grandfather, in a transaction with the original landowner, a black farmer named Moses Reed, who had owned the land since 1924. The deed was valid. It had never been superseded by a sale, a foreclosure, or an eminent domain proceeding. The property taxes had lapsed. Pam Kennison had stopped paying them after 2009 when her health declined. But in Georgia, lapsed property taxes do not automatically extinguish ownership. They create a tax lien. The county can sell the lien, but not the property itself, without a judicial foreclosure proceeding. No judicial foreclosure had ever been filed. The county had simply listed the property as surplus and sold it. Prescott's title attorney flagged the deed. He wrote an internal memo. Pre-existing deed found, Book 4417, page 312. Recommend quiet title action before proceeding with development. A quiet title action is a legal proceeding to resolve competing claims to a property. It's standard practice. It would have required Prescott to notify the Kennison heirs, including Siya, that the property was being claimed, and give them an opportunity to assert their ownership in court. Curtis Prescott read the memo. He wrote 2 words in the margin. Skip it. He didn't file a quiet title action. He didn't notify anyone. He bought the property from the city, broke ground, and started demolition on the abandoned laundromat 6 weeks before Siya was arrested for sleeping on land her family had owned for 60 years. Siya was arrested on a Tuesday morning at 6:14 a.m. 2 police officers woke her up and told her she was trespassing on private property. She was handcuffed, taken to the Fulton County Jail, and held for 9 hours before being released on her own recognizance. The trespassing charge was filed by Prescott Development Group's security contractor. The hearing was scheduled for 3 weeks later at the Fulton County Annex Courthouse, the same courthouse that sat on Block 3, the same block covered by the deed in Siya's Bible. Siya couldn't afford an attorney. She went to the Atlanta Legal Aid Society. A lawyer named Natalie Foster was assigned to her case. Natalie was 36, had been doing legal aid work for 8 years, and specialized in housing law. When Siya showed her the deed, Natalie went silent. "Where did you get this?" "My grandmother's Bible."
It fell out of the pages. "Do you know what this is?" "A deed for the block." "Siya, this is a recorded property deed from 1962. It's in the Fulton County records. It has never been transferred, sold, or foreclosed. If this is authentic, and I'm going to verify it today, you don't just have a defense against the trespassing charge. You own the property they're saying you trespassed on." Natalie drove to the Fulton County Clerk's office that afternoon. She pulled the record. Book 4417, page 312. The deed was there, exactly as described. James Kennison, 2.4 acres, Edgewood Avenue. Filed March 8, 1962. No subsequent transfer recorded. She called Siya that evening. "It's real, and it's yours." "What does that mean?" "It means Curtis Prescott bought property from the city that the city didn't own. The city sold it as surplus, but there was never a judicial foreclosure. The tax lien doesn't extinguish your family's title. You're the heir, and the land is still yours." "Including the lot I was sleeping on?" "Including the lot. Including the laundromat they demolished. Including the corner where the bus stop is. And Siya, including the building where your trespassing hearing is scheduled." Silence. "I own the courthouse?" "The annex building was built on your family's land in 1987. The county never acquired the title through condemnation or purchase. They built on it. For 37 years. Real quick, pause and drop a comment below. Tell me if you have ever been told you don't belong somewhere, only to discover that the place actually belonged to you. Share your thoughts, because this community is built on people who know the truth even when the system doesn't. The trespassing hearing was held on a Thursday morning in Courtroom 2 of the Fulton County Annex Courthouse. Judge Finn Sloan presided. He was 54, practical, and ran his docket like a factory floor. Cases in, cases out, minimum conversation. Siya sat in the back of the gallery. She wore the same clothes she'd been arrested in, the torn jacket, the jeans, the separating sneakers. She carried the plastic bag with the deed inside. Natalie Foster sat beside her. Curtis Prescott sat in the gallery on the opposite side. He wore a charcoal suit and a blue tie. He wasn't required to attend. The case was the state versus Siya Kennison, not a civil matter, but he wanted to watch. Gavin Hassler, his lead attorney, sat next to him. The assistant district attorney presented the case. Straightforward. Defendant was found sleeping on private property owned by Prescott Development Group. Defendant had no residence at the address. Defendant was asked to leave by security and refused. Charge: criminal trespass. Judge Sloan looked at Siya. "Ma'am, do you have representation?" Natalie stood. "Your Honor, Natalie Foster, Atlanta Legal Aid. I represent Ms. Kennison. Does your client have a defense to the trespassing charge?" "She does, Your Honor. The property on which Ms. Kennison was found is not owned by Prescott Development Group. It is owned by Ms. Kennison." A murmur went through the courtroom. Curtis Prescott leaned forward. Gavin Hassler's pen stopped. Judge Sloan raised an eyebrow. "Counsel, The property records show a sale from the county to Prescott Development Group 8 months ago. Your Honor, the county sold property it did not own. I have a deed recorded in 1962 with the Fulton County Clerk's Office. Book 4417, page 312, conveying 2.4 acres on Edgewood Avenue to James Kennison, Ms. Kennison's great-grandfather. The deed has never been superseded by a sale, transfer, or judicial foreclosure. The tax lien on the property does not extinguish the title under Georgia Code Section 48-4-40. The county's surplus sale was conducted without a quiet title action. The sale is void. Natalie approached the bench and handed Judge Sloan a folder. Inside, a certified copy of the 1962 deed, a title search report from the Fulton County Clerk's Office, a genealogical affidavit establishing Siya as the sole living heir, and a legal memo citing the relevant Georgia property statutes. Judge Sloan read the deed. He read the title search. He put down the folder and looked at Siya. Ms. Kennison, you're claiming that the property where you were arrested belongs to your family? Siya stood. Her voice was quiet but clear. Yes, Your Honor. My great-grandfather bought it in 1962. My grandmother lived on it for 40 years. I grew up there. The city tore down the house and sold the land. Nobody told us. Nobody asked. Judge Sloan looked at the assistant DA. Was a quiet title action conducted before the surplus sale? The ADA checked her file. I don't have that information, Your Honor. I do, Natalie said. No quiet title action was filed. No notice was served on any Kennison heir. The county bypassed the standard title clearance process. And Prescott Development Group's own title attorney identified the deed before the purchase and recommended a quiet title action. She held up a second document. This is an internal memo from Prescott's legal team, obtained through a public records request filed with the city's development office. It was included in the due diligence file submitted to the county as part of the purchase approval. The memo recommends quiet title action before proceeding. Handwritten in the margin, in Mr. Prescott's handwriting, skip it. The courtroom erupted. Reporters in the gallery reached for their phones. Curtis Prescott whispered to Gavin Hassler. Gavin was already pale. Judge Sloan banged his gavel once. Order. He looked at the deed again. Then he looked at the memo. Then he looked at Siya Kennison, a homeless woman in torn sneakers standing in a courtroom that was built on her family's land. The trespassing charge against Ms. Kennison is dismissed. You cannot trespass on property you own. He paused. He removed his glasses. Additionally, I am referring this matter to the Fulton County District Attorney's Office for investigation of the surplus sale, the failure to conduct a quiet title action, and the evidence that Prescott Development Group knowingly acquired property with an unresolved pre-existing title claim. I am also referring the matter to the Georgia Real Estate Commission for review of the county's surplus land procedures. He looked at Curtis Prescott. Mr. Prescott, you are not a party to this proceeding, but I'd suggest you retain counsel, because the property your $400 million project is built on may not belong to you. If you love your mom, you need to subscribe right now, because at the end of this video, I am revealing one thing Siya's grandmother did in 1998 that nobody knew about. And when I show you what Pam Kennison left inside that Bible besides the deed, you will realize this grandmother saw the future and prepared for it. Trust me, the secret is worth the wait. The dismissal of the trespassing charge was the first domino. The second fell within a week. The Fulton County District Attorney opened a formal investigation into the surplus sale of Block 3. Records showed that the county's surplus land office had processed the sale without conducting a standard title verification, a step required by county policy for any parcel valued above $500,000. Block 3 was valued at $1.2 million. The title check was listed as completed in the file. It had not been completed. The third domino. Prescott's title attorney, the one who wrote the Recommend Quiet Title Action Memo, was subpoenaed. He testified that he had flagged the 1962 deed directly to Curtis Prescott. He testified that Prescott had instructed him to proceed without the quiet title action and to handle the title risk through insurance, not litigation. The title attorney had followed orders. He had not reported the discrepancy to the county. The fourth domino. The county's surplus land office was audited. Of the 23 parcels Prescott had purchased for the Edison project, 7 had incomplete title searches. 3 of those 7 had pre-existing deed claims that had never been resolved. Block 3 was the most significant, but it was not the only one. The fifth domino, the one that stopped the entire project, came from Natalie Foster. Natalie filed a civil lawsuit, Kennison versus Prescott Development Group and Fulton County. The claim: fraudulent conveyance, constructive fraud, title defect, and violation of due process. She sought an injunction halting all construction on Block 3 and a judicial determination that Siya Kennison was the rightful owner of the 2.4-acre parcel. The court granted the injunction. All construction on Block 3 stopped. The cranes went silent. The workers went home. The $400 million Edison project, 4 city blocks, of which Block 3 was the geographic and commercial center, was frozen. Curtis Prescott was furious. He called a press conference and said, "This is a shakedown. A homeless woman with a piece of paper is trying to extort a $400 million investment in this city's future." Natalie Foster held her own press conference the next day. She stood on the sidewalk in front of the vacant lot on Edgewood Avenue, the lot where Siya had been sleeping when she was arrested. The piece of paper Mr. Prescott is referring to is a property deed recorded with Fulton County in 1962. It has been in the public record for 62 years. Mr. Prescott's own attorney found it during the title search and recommended legal action to clear it. Mr. Prescott wrote, "Skip it," in the margin. He chose to build a $400 million project on land he knew belonged to someone else. And then he had the owner arrested for trespassing on her own property. She paused. If there is a shakedown here, it was conducted by the man with $2.8 billion, not the woman sleeping in a parking lot. If you are still watching, you are exactly the kind of person this channel was built for. Hit that subscribe button so you do not miss the next episode, because this exact pattern of property theft from black families shows up in another billionaire real estate case I am covering soon. And the 1962 deed that protects Siya here becomes even more important in that story. The civil case was settled 8 months later. The terms were sealed, but the key outcomes were reported by local press. Siya Kennison was recognized as the rightful owner of the 2.4-acre Block 3 parcel. Prescott Development Group was required to pay $14.8 million for a negotiated long-term lease of the land, allowing the Edison project to continue on a modified footprint, with Siya retaining permanent ownership and receiving annual lease payments of $620,000 for 40 years. Fulton County was required to pay $3.2 million in damages for the unlawful surplus sale and to reform its surplus land procedures, including mandatory title verification, quiet title filing, and heir notification for all future sales. Curtis Prescott was not indicted. Billionaires rarely are for real estate maneuvers. But the Georgia Real Estate Commission censured his firm for material failure to disclose a known title defect, and the SEC opened a review of the Edison project's investor disclosures because Prescott had raised $160 million from investors without disclosing the Block 3 title risk. 3 investors filed civil suits. One was settled for $22 million. But here is the detail I told you to wait for, the secret that nobody understood until after the settlement. When Natalie Foster first examined the deed, she noticed something unusual. The deed was folded inside a second piece of paper, a handwritten letter on ruled notebook paper, undated, written in the careful, deliberate script of a woman who had learned to write in a one-room schoolhouse. The letter was from Pam Kennison, Siya's grandmother. It read, "To whoever finds this deed after I am gone, My father, James Kennison, bought this land in 1962 with money he saved for 19 years working at a sawmill on Memorial Drive. He paid cash. He recorded the deed at the courthouse because a black man in Georgia who doesn't record his deed will have his land taken. He knew that. He was right. This land has been in our family for longer than I have been alive. The city has been trying to take it since I was a girl. They will not stop. They will say the taxes are overdue. They will say the property is abandoned. They will say we don't exist. But this deed says we do. I am putting it in my Bible because that is the one book I know my granddaughter will open. Siya, if you are reading this, the land is yours. Don't let anyone tell you otherwise. Don't let them build on it. Don't let them sell it. Don't let them say you don't belong there. You belong there. Your father belonged there. My father belonged there. And this deed is the proof. Keep it safe. Keep it close. And if they come for it, show it to a judge. With all my love, Grandma Pam. Siya had not read the letter when she found the deed. She had unfolded the deed, seen the legal language, and placed it in her Ziploc bag. The letter, folded around the deed, had stayed in the Bible. Natalie found it during the case preparation, pressed between Psalms 23 and Psalms 24. Pam Kennison had known. She had known the city would try to take the land. She had known nobody would tell Siya. She had known the Bible was the one thing Siya would carry with her no matter what happened. And she had put the deed there, with a letter that told her granddaughter exactly what to do. If they come for it, show it to a judge. Siya showed it to a judge, and the judge listened. Siya Kennison moved off the street 4 weeks after the settlement. She rented a 2-bedroom apartment in East Atlanta, the first lease she had signed in 3 years. She brought May home. Her daughter was 8 now. She had been living with Siya's cousin for over a year. The first night in the apartment, May walked through every room. She opened every closet. She turned every faucet on and off. She tested every light switch. "Mommy, we have hot water." "We do." "We have a stove." "We do." "We have a door that locks." Siya knelt down and held her daughter. She held her the way Pam used to hold Siya, tight, long, the kind of hold that says, "This is yours now. Nobody is taking this." "May, one day I'm going to take you to a piece of land on Edgewood Avenue. It's our land. Your great-great-grandfather bought it in 1962. Grandma Pam lived there. I grew up there. And it's going to be ours for a long time. Can we build something on it? Eventually." "What?" Siya looked at the Ziploc bag on the kitchen counter. Inside, the deed, the documents, and Pam's letter. She had carried it in a plastic bag for months. She would need to put it somewhere safer now, somewhere permanent. "I don't know yet, but whatever we build, it's going to have a plaque. And the plaque is going to say, Kennison Family Land since 1962. You belong here." May smiled. "Can it also say, hot water available?" Siya laughed. It was the first time she had laughed in a long time. The sound filled the apartment the way sound fills a room when it's been empty for too long. Slowly, then all at once. Natalie Foster continued representing Siya pro bono for the next 2 years, managing the lease payments, the trust structure, and the ongoing compliance with the settlement terms. She never charged Siya $1. When asked by a reporter why she took the case, Natalie said, "Because a deed is a deed. It doesn't matter if you find it in a safe or in a Bible. It doesn't matter if the person holding it lives in a penthouse or on a sidewalk. The law is supposed to be the same." Pam Kennison's Bible sits on a shelf in Siya's apartment. The deed has been moved to a safe deposit box at a bank on Auburn Avenue, 4 blocks from the land it describes. But the letter is still in the Bible. Siya reads it every night before bed. Not for the instructions, for the handwriting. for the feeling of her grandmother's words on the same pages she touched. On the last page of the letter, below the signature, Pam had added one more line. Siya didn't notice it until the second month in the apartment, when the light hit the paper at the right angle and the faded pencil marks became visible. P.S. Psalms 24:1. The earth is the Lord's, and the fullness thereof, but this block is ours. Curtis Prescott spent $400 million building a project on a block he didn't own. He had 23 lawyers, a title search team, fast-tracked city permits, and a press conference where the mayor shook his hand. He had everything a billionaire needs to take what he wants, except one thing. He didn't have the deed. The deed was in a Bible, in a plastic bag, in the hands of a homeless woman sleeping on the same dirt her great-grandfather had bought with 19 years of sawmill wages. She didn't know what the deed meant when she found it. She didn't understand the legal language. She just knew it had her family's name on it, and she carried it everywhere, through shelters, through nights on concrete, through an arrest on her own property. A billionaire's legal team found the same deed during their title search. They read it, they flagged it, they recommended action, and the billionaire wrote 2 words: skip it. He skipped it because he assumed nobody would ever come looking. He assumed the heirs were gone. He assumed a black family's 1962 deed was a relic, not a weapon. He assumed wrong. Siya Kennison was homeless. She had no money, no lawyer, no power. But she had a piece of paper that said her family owned the ground she stood on. And when she showed it to a judge, the $400 million project stopped. The cranes went silent.
The construction halted. And the man who wrote "skip it" spent the next year explaining to investors why he built a $400 million development on land a homeless woman owned. Some people think property is about who has the money, but property is about who has the deed. And a deed recorded in 1962 by a black man who saved for 19 years and walked into a courthouse because he knew that a black man in Georgia who doesn't record his deed will have his land taken. He recorded it. 62 years later, his great-granddaughter pulled it out of a plastic bag in a courtroom and proved him right. The land is still theirs. Click the video on your right to see the 3 other corporate espionage cases where self-representation destroyed billion-dollar companies. The legal loopholes they exploited and the one statute that changes everything. You will see the patterns these strategists use, the mistakes their opponents make, and the exact moment when the trap closes.